I said, okay, now you shut your eyes and let your companion judge explain this question to you. But I couldn't do that in the court, unfortunately.
That makes a lot of sense. That makes a lot of sense, actually.
It does make, but one of the problems with our judiciary is that they sit on a higher platform than us, and we have to be careful in how far and how much we can push them.
No, when you are making that point, you're not acting like a lawyer. Sir, can I make an appeal here? Slowly.
Yes, absolutely. And in fact, sometimes I find that having the person with disability or the organization sitting right next to you makes a big difference sometimes. I think we'll keep over this. We won't translate that regarding this last one, reasonable accommodation.
सेंस का केस है कि जिस जावेद आबिदी ने 1-2 केसेस फाइल किए थे एयरलाइंस के लिए हवाई जहाज में डिसेबल लोगों के साथ जो उनको हवाई जहाज में नहीं चढ़ने देते हैं या उनके लिए फैसिलिटीज नहीं होती हैं उसके ऊपर केस फाइल किया था। और एक इम्पोर्टेंट पॉइंट जो मिस्टर माली ने कहा वो ये कि जो भी इंसान या ऑर्गेनाइजेशन या संस्था ऐसे केसेस फाइल करती है तो जब केस फाइल करती है तो सब उसमें बहुत इन्वॉल्व हो जाते हैं और कोर्ट भी अपना इंटरेस्ट दिखाता है। मगर अगर उसको चाहे उसका जो भी नतीजा निकले, चाहे कोर्ट आपके फेवर में डायरेक्शन दे, मगर आपको उसको फॉलो अप करते रहना पड़ता है। जैसे नहीं तो फिर ये ऐसे इंस्टेंसेस लोगों के साथ बार बार होते रहते हैं, तो उसको फॉलो अप करना बहुत जरूरी होता है। और रीजनेबल अकोमोडेशन में भी जजेस को उतनी समझ अभी नहीं है इस कॉन्सेप्ट के बारे में, तो इसके ऊपर भी लिटिगेट करना जरूरी है।
I understood in the courts in developed countries like the US and the UK, it is a standard practice in US courts, for example, that if a person who acquires a disability during their employment and gets terminated, then the courts have disallowed that termination and have said that first examine the question of reasonable accommodation. And it is the burden on the employer to show that there is no possible reasonable accommodation and that the person has to be dismissed. And that goes for the private sector as well. And there are 4 cases listed on that. And my last slide for today, I know we are running a bit late. Just briefly that the legal approach is not an overall panacea. One must understand this. Persons with disabilities come and talk with lawyers and discuss their problems. But there are issues with the legal recourse, legal advocacy, giving the desired results. There are some weaknesses in the approach. One is the legal foundation. As I said earlier, that we do not have anti-discrimination provisions in the private sector. So, for example, if there is a shopping center which is not accessible, or if you go to a shopping grocery store, and the shelves are too high for a person with disability to actually reach, we cannot file any cases against such entities in India, whereas it is possible in the developed countries. We already discussed this, that the reasonable accommodation concept which is there in the UNCRPD is not available in our Act directly, and this would be one of the most important amendments I could think of to our Act, is to specifically include the idea of reasonable accommodation so that we have a broader set of grounds on which we can approach the courts. For example, if I talk about the marked relaxation case, if the concept of reasonable accommodation is well understood, then the court would understand that in order to fill all the reserved quota seats, you might as well give the same relaxation to the disability category as you would give to any other category. The sensitivity of the court is very important and varies a lot. I just gave the example of Justice A.K. Sikri in the High Court, who is an example of a very, very sensitive and a concerned judge when it comes to persons with disabilities. On the other hand, as I mentioned, in the administrative tribunals, you may have a judge who does not even understand that a visually oriented question cannot be answered. So, the last point there I said is a lost case, really a lost case. This mirrors the point of Professor Thanda, that even in such instances where you do not have a sympathetic court, the point is that fight has value. Even if you lose the case, it has value, because then somewhere in the mind of the court, this idea has come in. And maybe after saying no once, twice and thrice, the 4th time they would say yes. Possibly. And the last point, of course, in the Indian system, timeliness is an important aspect. We must try to convince the courts that when it comes to persons with disabilities, this is an important avenue. Legal advocacy and the legal approach is important, and we would expect the court to fast track the cases so that some amount of relief is obtained. And I think I'm done with that.
Great.
Thank you. My disability in Hindi was exposed today.
So was mine. We'll take the questions after Pankaj has done his presentation. एक बार दूसरे पैनलिस्ट भी अपना प्रेजेंटेशन कर लें, फिर सबके क्वेश्चन एक साथ, सबके सवाल एक साथ देंगे. पंकज हमारे HRLN के लॉयर हैं दिल्ली के ऑफिस में, और वो डिसेबिलिटी पे कई केसेस कर चुके हैं और कर रहे हैं. ये हमारे डिसेबिलिटी इनिशिएटिव के बहुत इम्पोर्टेंट वकील हैं, और इन्होंने जो केसेस किए हैं ये उसके बारे में बताएंगे.
Is it okay if I speak in Hindi to all of you?
Okay.
Can everyone understand, or I should speak? Because it's very difficult to speak mixed language.
The information is in English and PowerPoint, so we
Okay, fine. I don't know how to speak it. Okay.
Yeah, the information is in English, so you can speak in English.
Okay. I'll give you a glimpse of certain cases which I have done in High Court. मैं एक झलक दूंगा जिसमें आप सब देखेंगे कि कितने केसेस किए हैं, और ये सारे पब्लिक इंटरेस्ट लिटिगेशन है, जनहित याचिकाएं हैं. और इसमें इससे पहले मुझे प्रोफेसर डांडा का स्पीच याद आता है. आई जस्ट रिमाइंडेड ऑफ हर स्पीच वेयर शी वाज सेइंग दैट यू कैन यूज UNCRPD विदाउट इवन डिस्पाइट द फैक्ट दैट यू नो बिकॉज you can use the UNCRPD, although Constitution does not mention the word persons with disabilities in Article 15. तो UNCRPD में वही हमने यूज किया है इन सारे केसेस में. There is no other laws which have been used, neither PWD nor any other act. And the credit of using all these laws not goes to me, it goes to none other than Mr. Rajiv Gandhi, to whom we should give a big applause. As he is the one who told me that Pankaj, you should use UNCRPD as much as is possible. And when I joined HRLN, he told me that within 6 months I want you to use UNCRPD. So first case I filed is which is called National Association of the Deaf versus Union of India. ये केस है जो this case pertains to grant of driving license to the persons with hearing impairment. इसमें क्या था कि जितने श्रवण बाधित लोग हैं उनको ड्राइविंग लाइसेंस दिलाने के लिए केस फाइल किया गया था. और इसमें इस केस को फाइल करते समय हमने 2-3 आर्ग्यूमेंट्स रखे थे कि अगर एक बाहर के नागरिक, एक बाहर का जो when there is a citizen who is non-resident Indian and he is a deaf, if he is issued a driving license and comes back to India, he is allowed to use the same driving license. But when you are a citizen of India and you are residing in India, you are not allowed to use the same. You have to have the same. So we said, why should there be discrimination on the ground of citizenship? This is one question which we posed. Then second question was that India was one of 26 countries which did not provide the driving license. So we argued there were many points, and finally we got the decision in our favor on a very crucial day, which is 14th of February 2011. So तो ये जजमेंट हमें मिला था 14 फरवरी 2011 को. That was my first victory also. हमें ये जजमेंट मिला कि अगर डेफ पीपल भी, अगर हियरिंग इम्पेयर्ड लोग भी कॉम्पिटेंट हैं तो उनको टेस्ट के लिए बैठने दिया जाना चाहिए. इफ दे आर फाउंड कॉम्पिटेंट, वो योग्य है टेस्ट में, तो उनको ड्राइविंग लाइसेंस भी दिया जाना चाहिए. तो ये हमारा एक पहला केस था जिसमें ड्राइविंग लाइसेंस जो है हियरिंग इम्पेयर्ड को लोगों को दिया गया. अगला भी हियरिंग इम्पेयर्ड लोगों का ही इशू है. सेम पिटिशनर है नेशनल एसोसिएशन ऑफ द डेफ, और जो रिस्पोंडेंट है यूनियन ऑफ इंडिया. और ये लेकिन केस है वो है साइन लैंग्वेज इंटरप्रेटर्स. This is an issue of sign language interpreters, appointment of sign language interpreters at all major public places. तो इसमें क्या हुआ था कि we just raised the we use again UNCRPD. As I have told you that I have used UNCRPD in all my cases. So ये कि इसमें हमने बोला कि जितने भी बड़े पब्लिक प्लेसेस हैं वहां पे साइन लैंग्वेज इंटरप्रेटर्स होना चाहिए, बिकॉज इट इज अ नेसेसिटी, इट इज अ नीड, इट्स अ फंडामेंटल नीड विदाउट विच अ डेफ पर्सन कैन नॉट सर्वाइव। ये हमारी एक बुनियादी आवश्यकता है हर श्रवण बाधितों की, जिसके बगैर वो नहीं रह सकता। तो इसमें कोर्ट ने ऑर्डर किया कि हाँ कि साइन लैंग्वेज इंटरप्रेटर्स आइडेंटिफाई किए जाएं। यूजीसी को भी डायरेक्शन आदेश दिया गया कि आप यूनिवर्सिटीज के साथ कोऑर्डिनेट करो और साइन लैंग्वेज इंटरप्रेटर्स अपॉइंट करो। और ये जो केस था इसमें भी हमें ये ऑर्डर मिला कि हर बड़े पब्लिक प्लेसेस पर, मेजर पब्लिक प्लेसेस पर साइन लैंग्वेज इंटरप्रेटर्स अपॉइंट किए जाएं। सो दिस वाज अगेन अ मेजर विक्ट्री। You cannot even imagine what will be the situation of deaf people in the absence of sign language interpreters. It's like like if I am sitting here and I do not have Braille, you can imagine what will be the situation. So the survey उनको ऑर्डर किया गया कि सर्वे करके और साइन लैंग्वेज इंटरप्रेटर्स हर जगह अपॉइंट किए जाए।